I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today. And we have a very special guest from one of those I states as well. We've got Polly Dobbs from Peru, Indiana. Polly, why don't you introduce yourself to our listeners? Tell us about you and your law practice.
Hi, Carrie. Thanks for having me. So I am an estate attorney. Spent the first 12 plus years of my practice in downtown Indianapolis, going to work at a big law firm in a high-rise building. But I am from a family farm and grew up in 4-H, very active in agriculture and Angus cattle. And so along the way, my law practice moved home to my family farm. And after a few years, I left the big firm and ended up starting my own law practice. But I've only ever been an estate planning attorney. So I'm not a general practice lawyer. I can't help with other areas of the law, but I do estate planning very in depth. And over the years, I have morphed into this niche of farm succession planning because there are not a lot of lawyers who do estate planning who understand ag. So the law, as you know, is not different for farmers. The law is the same for everyone. It's the vocabulary, the just understanding of the industry and how family farms work. That's what's different. If your lawyer doesn't speak your language or understand your balance sheet, it's going to be hard to get the right plan in place.
Yeah, absolutely. And Polly, I'm so interested because I am a cattle girl myself. I grew up on a Simmental. We have some Angus as well, kind of a Sim Angus operation in central Illinois. And what led you to wanting to go to law school in the first place?
So when I was in undergrad, I sampled several different majors before I could decide what I wanted to be when I grew up. And then, like most college students, you don't know. So my first job out of college was in state government. I was a governor's fellow. So they rotate young college graduates through several different state agencies. And during that time, I was working with lots of lawyers who were in state government, lots of employees who were going to night school to become lawyers. And I thought, I think I might really like that. But even at the outset, I knew I wanted to be a transactional attorney. I have a math brain. You know, if you have left brain, right brain, I'm the math side of the brain only. So I knew I didn't want to be a litigator or somebody who briefs cases and goes to court and argues. I wanted to be like a math lawyer where I'm doing tax law and transactional things. So I don't go to court. I try to help families put together plans that keep people out of court because there's nothing to sue over when it's nice and clean and laid out properly.
Polly, do you do any probate or are you just really on the estate planning side of things?
I do some probate. Typically, if they were my clients during lifetime, they put together a plan that will avoid probate. I don't necessarily push that. It just seems to be sort of how things work out. But I get lots of calls from people who say, hey, my dad died. What do I do with the family farm? I say, well, did dad have a will? You know, kind of fingers crossed.
Yeah.
Let's talk about it. So yes, certainly we do the probate side of it as well. But our focus is on the planning side.
So Polly, I'm interested. What did you study in undergrad and where did you go to school?
My undergrad was at Ball State. And first I studied music. I was going to be a music performance major. Pretty quickly realized that was more of a hobby for me than a career path. And it was actually my music professor who said, no, you're a mathematician. The way you look at music is how many beats per minute, and it's a math formula to you. It's not a passion of musical performance. And so I was almost an actuary. For 3.5 years, I was an actuarial science major and passing the tests along the way to become certified in that. And just realized, hey, I like math, but I like people too, and I can't be in a cubicle in an insurance
Mhm.
company for the rest of my life. So I rounded out with a history major and math and business minors, which really set itself up nicely for law school. Um, and then in grad school, I was a joint degree student. So I got my MBA at night and went to law school during the day. So I came out with both. And that put me right in a transactional practice in a big law firm in Indianapolis.
So you really do have a strong, financial background, which I'm sure certainly serves you well with this farm estate and succession planning.
Yeah, really, um, it's what made it easy for the partners at my law firm to bring me to the table sooner than other young associate attorneys, because there's a whole lot of lawyers who cannot read balance sheets, financial statements, cash flow statements. They don't understand what any of that is. So again, I'm a math lawyer. I've got the numbers behind it. I'm not a CPA, but I know a whole lot about the income tax side of things, where my focus is estate taxes, estate planning. I also do a whole lot of planning around retirement, and so that involves income tax consequences. So much of what I do is in a team approach with the client's CPA to make sure that nothing slips between the cracks and that everything's handled appropriately.
So, Polly, you do a lot more farm estate planning than I do, but I know when families come into my office, a very common question or a very common statement that is said is, I want to treat all my children equally. I want to make sure everybody gets the same inheritance. Do you think that that is a good idea or a bad idea, and why?
I think it's a terrible idea, uh, but that is how most parents feel. I got to be equal with my children, and so you and I and other lawyers who have these conversations, we need to give our clients permission. It is okay to treat your kids differently. Everybody doesn't have to inherit the same thing or the same percentage of each asset. And I feel like a good chunk of most of my initial meetings are spent just taking the blinders off my clients and trying to get them to think outside that box that you
Well,
are
what do you
allowed.
say to them then? If they come and like, I have 3 kids, everything needs to be a third, a third, a third.
Well, if all 3 kids are involved in the farm and can get along well and be in business together, maybe that's feasible. But the way I explain it is, if your kids are not in business together now, they probably shouldn't be in business together when you die. And having everybody own an equal share of every asset is slapping them together in a business arrangement that is doomed to fail. Uh, it's
Hmm.
it is tricky. So folks will oftentimes just stare at me blankly and say, "Tell me what to do. I don't know what to do." And that's really hard for me. But I can go through some examples. And then once I gather some information from them, then I know which path we're probably going down. I wish that it was easier and I could sell everybody the same plan and it was just like selling widgets, off a factory line. But every family's so incredibly different. I spend a lot of time just coaching them to find what feels fair and stop talking about equal. And maybe it's a good idea to have all the farm assets go to one kid and cash or life insurance and other assets go to different kids. Maybe that's feasible. But if it's not, if you start thinking about the farm differently, operating assets in one bucket separate from land in another, that can make it a little bit easier to find a fair balance if all the farm to one puts the teeter totter off kilter because there just aren't any other assets.
So
Then maybe we can work.
what do you do, Polly? I guess something that I've done with my clients is sort of reality test certain scenarios, right? What if this happens, or what if we do this, or what is sort of your process on when you're collecting that information for that particular farm family to ascertain which path or package is best for them?
So I really have them focus on, what if you died tomorrow? based on today's circumstances and who is actively involved in your farm operation and who isn't, what would be the right fit if you died tomorrow? Because so many times clients get hung up on the starting line and they can't even start the plan because they're so worried about, well, what if in 20 years somebody comes back from college and wants to farm with us, then what? Well, if you're still alive, you just dust off that plan and adjust it and make sure it fits the new circumstances. Uh, but until my clients can tell me when they're going to die and what they're going to own on that date, I can't do a perfect plan. I can just help them get the safety net in place so that if they die tomorrow, everything's going to be all right.
Yeah, absolutely. Polly, I don't know about your neck of the woods, but I know that there's some farmers in my community that if I was going to ask them what would happen tomorrow, they don't know, they would not know the answer to that question, nor do they have an heir that may be interested in taking over the farm. So they're looking at actually like off-farm, heirs, perhaps, or I'm sorry, not off-farm heirs, but just off-farm persons that might be able and willing to take over the farming operation. So I don't know your perspective about that in Indiana.
It seems to be the new wave of planning is non-related successors.
Mhm.
Because my farm clients will sit at my conference room table and brag about how successful their children are in Brooklyn and in San Francisco, and they've moved away and they're wildly successful. And they're looking forward to retirement, and they want to know, well, what do I do with all this machinery and equipment? My kids will never farm. So that's very important retirement planning for the farmer, and it might involve a sale to a non-related successor, maybe a longtime employee that we can package up the operating assets and sell them in an income tax efficient way to some successor operator, and the kids can inherit the land. And maybe they keep it and maybe they don't. Every family's goal is different for that. I don't try to impose my goals of farmland legacy on top of my clients. For some of them, they say, "Ah, the kids can sell it. I don't care." So I tailor the plan to meet their goals.
So to talk a little bit more about this issue of fairness, do you think that this is really an issue that your clients alone should really be discussing, or do you think that this should be a discussion that should be done with the whole family together?
So I'm very clear that with my clients, these are your assets. You decide what happens.
Mhm.
Okay, we're not taking a vote, but I do encourage taking a poll of the next generation. And I'm a huge proponent of transparency and of open communication. The biggest problem in any estate plan is this sense of entitlement that may be brewing at the next generation. And if you don't talk about the plan and make it very clear what's supposed to happen, somebody's already calculated how much they think they're going to inherit and what that's going to look like. And if the plan doesn't unfold that way, there can be really serious problems.
Mhm.
Lawsuits, family feuds, cousins never speak to each other going forward. So I'm a huge proponent of transparency and open communication, but that's tough. I mean, farmers just do not talk about money, and it's really hard to get some folks to crack open and share some details. They don't want to hurt anybody's feelings. A lot of times I will be facilitating a family meeting where the farmer just says, "You tell them, Polly, you tell them how it's going to be," because they don't want to have to explain to their children. So even that's better than nothing, because we just want to avoid surprises and quash entitlement.
Yeah, what would be your suggestions for those farm families where they're trying to do X, right, and they know that is going to cause some major conflict among their children, right? What would be your suggestions for them to sort of work through that?
Well, sticking your head in the sand and ignoring it only makes it much worse.
Mhm.
So um, it's that is a very tall order, and I don't have a magic wand. I cannot make it easy or pleasant. I can just help muddle through. A lot of times it works out well if we have separate conversations before everyone is together.
Mhm.
And sometimes, individual discussions or interviews with different family members ahead of time is great. but maybe that's not necessarily the estate planning lawyer's job. There are a lot of other consultants and people involved in succession planning who thrive on the softer side, on those sorts of communication and different personalities and all of those things that sometimes I'm not best suited for that. You know, I'm nuts and bolts, black and white tax attorney. You tell me what you want and I'll write it down. And I'm happy to communicate with your family, but maybe not my hourly rate for legal services for that softer side of the hand holding and the emotional issues. Maybe that's not the right fit. But that brings me back to the team approach. You know, there should be more than one person helping the family with this transition. And a counselor or a more consulting type role can be hugely helpful and much more efficient than just trying to slog it out with a lawyer.
Yeah, absolutely. So Polly, I'm curious. I feel like a lot of people in general, but particularly farmers, do not like to talk about money. All right. It's a sensitive issue. It can sometimes be taboo at the dinner table to bring all this stuff up. And so, what is your suggestion for those people to sort of begin that conversation to really talk about finances?
So a lot of times I say, blame it on me. I write a lot of articles. I go to seminars in the winter, and I tell everybody, go home, say, we just saw this lady lawyer talking last week at this seminar about how important it was to do X, Y, and Z. So use me as the conversation starter, or pull one of the articles off the internet talking about open communication and farm succession planning, and throw it on the table and say, hey, I read this, what do you guys think? Or, you know, the more passive way, forward an email to the family and say, here's some interesting things that we should probably be discussing, don't you think? Blame it on me.
I love that, Polly. I feel like lawyers have been the scapegoats, for so long, to have these tough conversations. But by the way, I don't know if you know this, but a high percentage of my practice is actually family law. So I do a lot of prenuptial agreements. This is what I would consider prenup season. It's in the spring for summer weddings, although in this climate, there are some weddings that are getting canceled right now. What is your thought on prenuptial agreements with family estate planning? I wrote an article that prenuptial agreements are romantic. Some people would disagree with that statement. So I'm curious on your perspective on that device.
I'm glad to hear you talking about prenups too, because it's one of my soapbox issues. I get up on my soapbox and preach that all farm kids need prenups, not just farm kids, but marriages in your golden years after you've lost a spouse and found love again, or if you're on your second, third, or fourth marriage. Prenups are even more important later in life because assets have been accumulated. But I consider prenups just a part of the succession plan.
Mm-hmm.
Because folks need to understand that a marriage certificate brings very strong property rights along with it. And some folks are shocked to realize, look, you can't disinherit your spouse. Even if she's spouse number 5 and you got kids from the previous 4, you cannot disinherit your spouse. You're entitled to assets at death unless that's been waived in a prenuptial agreement. So lots of folks think prenups are just for Hollywood, for the famous, rich and famous, or they only help if you're going to get divorced. And we're never going to get divorced, so we don't need a prenup. Well, this piece about rights at death, rights to elect against a will, statutory shares, spousal allowances, that can really upset the apple cart when we're trying to the farm. So do you hear that a lot in your practice? Keep it in the blood. Keep it in the blood.
Yeah, absolutely. I guess a common thing that I tell people is that nobody gets on a plane thinking that it's going to crash, but you still go over the safety instructions. So I look at the prenuptial agreement sort of like the safety instructions for a marriage, and marriage certificate, it is basically a contract, and the law that goes with that contract from state to state, depending on where you are. But even if you like the law at that particular time, you're like, we're good. We don't need to make any changes. The law could change during the marriage, right? And yeah, I couldn't agree more that prenups are not for the rich and famous. I mean, they're for people that want to take control over their lives and their assets and to make decisions about what's best for them and their family. It doesn't mean that one person's going to get hung out to dry there. It's just sort of keep in mind what's fair and equitable. And I think with especially multi-generational farm families, that everybody needs to be thinking about prenuptial agreements for sure.
Yeah, absolutely. And for starters, for starting that discussion, it can be really limited and only apply to the family farm. Any interests I own now in my family farm or may acquire in the future, buying in through gifts or through inheritance at death, that's all we're identifying as separate property that will not be considered in the event of divorce, and that you're waiving all rights to claim against at death. And anybody who won't sign that, that ought to be a red flag.
Hmm. Yeah, I know. And any of the well, what if I work on the farm? I mean, that person could still be an employee. I mean, there's all sorts of things that could still be done for contribution for services rendered there. But yeah, I agree with you that those issues definitely need to be um, thought through. So speaking of prenups, let's talk a little bit about spouses, Polly. And what are your thoughts with farm estate planning with some blended families?
So it it's very dangerous to have a sweetheart will in place that says, I leave everything to my spouse at death,
Mhm.
period. The spouse fully controls those assets, and there is no guarantee that the assets are ultimately going to make it back to the family, to the blood relatives. Um, Verbal promises mean nothing when it comes to real property. Um, it's very tricky. I get a call at least twice a month. Dad died and stepmom did XYZ. Well, of course she did. Dad wanted something else to have happened. He should have done some planning instead of just leaving it all to stepmom. So a lot of times I get accused of being too tough on stepmom. There's been a loving relationship there, and you
Mhm.
want to take care of that spouse. Absolutely. All the income off my farm to my spouse for life. We want her well taken care of. Like you said, we don't want anybody hung out to dry, but it's the control that's so important. Where's the ownership of that land going to be when the spouse then dies? And if we want to make sure that the farm isn't auctioned off and the money ultimately go to stepkids, some planning needs to be done. And these are tricky conversations, crucially important for blended families, but even in a regular old nuclear family that they've been married to each other for 40, 50, 60 years, when the first spouse dies, there are some risks. Second spouse can remarry. And, I point out it's not as if we don't trust the spouse that they would intentionally do something that made a family up. But in the golden years, a little bit of dementia starts creeping in, they'll sign anything. And sure, you can go to court and argue weren't competent, didn't have the mental capacity. Those things expensive and such a terrible process. It's better to have some protections in place, even just some simple, easy marital um, can be so incredibly helpful. So it doesn't. Um,
So Polly, let's walk through trust as a whole. And I'd love to know you agree with this analogy, but this is a common analogy that I tell people is that you you have fun, right? You do so with any type of asset, right? Um, so let's talk about. Would you agree with that analogy? How with marital trust? What does that look like as far as what put in the marital trust?
yeah, no, the trust can be anything the client wants it to be. And that's, I spend a lot of time explaining just because it's a horror story. My mother family had a trust and it was a disaster. Well, you want to people in charge, the trustee, you line up a few successors, and then a huge amount of flexibility. Just 'cause something fixed now, it might be different. Trustee renewal provisions, replacement protections, and what goes in there, and how you put your taxes or insurance, accountant to do a tax return. There needs to be a little bit to, seed money. That's a pun for a farmland trust, right? Um, trustee. One families, the spouse can be trustee. And there's just protection in there that if that spouse remarries and signs a will, what does govern this? This is in the trust. And then just depending on the family circumstances, you tighten it up and stricter, or you keep it loosey, just depending on their goals.
Right. So, Polly, is it your general recommendation then? I mean, I guess it depends on that particular farm family that there be a different person who would be the trustee, or would you have the spouse basically be in charge?
By case, depends on the family. And what I hear a lot, kind of back to that dementia, after we're worried that the surviving spouse will get bamboozled, they'll be taken advantage of by their stepchild. Some clients like the idea of their kids being co-trustee. So that if the surviving spouse is taking like that trust and selling it, kids are going to have to sign off on that. So, but in wife, and we don't trust her at all, then maybe it's an independent trustee. Sometimes it's a bank. Those are tricky. It is hard to find a local trust company to trustee of a trust that owns farmland. There aren't a lot of local trust companies left. When the local bank is bought up, some farm families don't like that idea. So kind of back to flexibility in the document and having removal and replacement provisions in place can be helpful.
So the farms in India, let's just say that you have not worked with, that perhaps are not successfully succeeding to the next generation, and when somebody dies, you can just see the for sale sign go up on the farm, and things sort of disintegrate. What do you think are the major problems there with those operations that could have possibly been remedied?
I want to make sure I understand your question. Can you rephrase it?
Sure. I guess my question for you, Polly, is that, when you're seeing farm families that perhaps don't have a proper estate plan put in place, right? They're not fully thinking things through, and the farm is not seed to the next generation, right? What are the biggest mistakes that you think that farm families are making in those instances?
So if somebody's already passed away, it's too late, and we just have to deal with it as it is.
Mhm.
I tell folks you can always voluntarily agree to anything, and when you find yourself in a bad spot because there wasn't proper planning during lifetime and someone has died, it is very important to draw the line in the sand and stop thinking about what could have been. What if dad did have a will? What if dad and stepmom did have a prenup? That is wasteful, and that doesn't help get to a practical solution and move forward. So I coach a lot about leave the past in the past and figure out the most practical way to move forward. Because if you fight and eventually you win, not really a win if it's months and years of fighting and fees and expenses. You're in a worse place than you had just compromised, worked out a way to buy each other out of the land, or buy each other out of the equipment, or partition it so that you each can own separate ground instead of co-owning everything together in a pot. So I'm a big advocate for practical solutions, even if legally that's not the right answer. And after a protracted lawsuit, you might win that argument. If we can find a practical solution sooner rather than later, That's where we want to be. Get you past this speed bump into a fresh path forward to the future and leave this in the past.
I love that, Polly, because I feel like so often, families are going through whatever kind of struggle that it is. It's so easy to place blame on something or someone, but to just have that go forward moment. Okay, this is where we are. What is the best path now? So to kind of focus on the future. I love that.
And
to go in, go ahead.
Just to follow up to that, estate planning is something that most folks want to procrastinate, put on the back burner because they're never going to die. They don't need to worry about this till later, till they're older. But I will say that when a family's gone through a tragedy, poor planning, and bad consequences happen, those are my most eager estate planning clients. The son who's just watched his dad farm get divided among off-farm heirs and stepmom, he will be real eager to make sure that his piece of it is planned for properly. So that's maybe the silver lining, that you get some good plans in place after they've suffered through a bad one.
But Polly, why does it take that moment? Right? Why is it, and I will not ever understand this, is why is it that estate planning does not feel urgent, does not feel important, that we can put it off? Why is that, Polly?
Well, it's just no one wants to face their own mortality. You're never going to die. You have plenty of time to figure it out later until you don't. It's just like the dentist with bad teeth, or the cobbler's kids have no shoes, right? Like you've always got later to deal with that until you don't. So that brings me back to just this theme of have something in place that fits today's circumstances. What are your assets? What are your debts? What's the law? And what's your family look like? And then if any of that changes in the future, dust it off. Because this estate tax law changes all the time. Anytime there's an election, they like to move it around. So a perfectly great plan from 2009 might have a bad consequence now. So it's important to dust it off and make sure it still fits.
I hate it when people ask me this question because it is so different for every family or for every divorce or every client that I work with. But could you just walk me through just sort of the general process of a farm estate plan? How does that work just from a broad strokes basis?
So there's the information gathering phase, right? I'm brand new to your family. I don't know anything about you. So I ask my folks to fill out an inventory outline ahead of time. So I spell all your kids and grandkids' names right. I have a rough idea if you've been married before, do you have wills in place? Have you ever made taxable gifts and used up any of your exemption? And then home base for any estate plan is the personal financial statement, and it needs to be accurate. And I am shocked at how often that's so difficult to get. So it needs to be accurate. What do you currently own right now? How is it titled? Is it joint? Is it just one or the other spouse's name on it? Have they added POD or TOD? Because lots of times bank tellers turn themselves into estate planning attorneys just by how they set up the accounts. And then for a bulk of the client's wealth, it's not even going to be governed by the documents I draft. It's going to be governed by a beneficiary designation. So anything that's a contract, IRAs, you get a lot of farmers doing these SEPs and cash balance plans and things that are meant to divert taxable income for deferred growth, but they will all be governed at death by the terms of the beneficiary designation. So I need to know what those currently are. Clients don't know. It's not on the monthly statement. It doesn't say who your beneficiaries are. You're going to have to go dig and find out who you named on whatever day you open that account up. Or if you skipped it, the fine print probably makes it payable to your estate or whoever.
Or probably, or they think they changed the beneficiary, but they don't know for sure. And so I think that just that process alone is worthwhile for everybody to go and do their due diligence there on who their beneficiaries are. So, Polly, I'm sure that you've received some pushback, even just with that stage, with the information gathering stage. Polly, why do you need to know all this information? Like I told you, I just want a simple plan. I have 2 kids. I just want to give everything to my kids 50-50. Like, why do I have to fill this out with all my farm equipment inventory? What do you say?
Yeah. Well, I can only give you good advice if I have good information. So if you don't want me to talk to you about estate tax planning or helping you find a fair balance among children, you know, a lot of clients, if they're putting together a personal financial statement for their banker, they put their life insurance down at cash value, but I care what my clients are worth dead. So I need to know the death benefit of all that life insurance and how much is going to be included in the gross estate. And in addition, who the current beneficiaries are. So I see all sorts of messes. And so what I explain to clients who don't want to tell me all that, you know, they think I'm nosy. It actually will take me more time to do the estate plan if I have less information. I feel like clients who are withholding, it's because they want me to work as fast as possible. No, you don't need to know any of that. Just give it equally to my kids, like you said. And then on the back side of it, we're so just pulling at strands, grasping at straws, trying to get information that we don't have. I would much rather have the client who walks in with 2 suitcases full of documents and throws them on my table, because pretty quickly I can go through and say, I only need these, and now I'm good. And it's much more efficient when we have complete information. So a lot of times you'll find that the ex-wife's still named on the life insurance or the retirement plan, and right there I've done their family a huge favor by cleaning up that future mess.
Do you ask your clients to try to gather up the copies of the deeds and things?
I do. And it's very ironic that the most valuable asset my client owns, it's the hardest thing for them to produce. They bring the abstract of title. I don't care. That's not helpful to me. That rolled up yellow piece of paper, that's not helpful. I need the most recent deeds of record. And then they don't tell me about the exceptions out. Well, the highway widened, or we sold off an acre for a house to be built, or there's a NIPSO substation there now. So that process alone is a huge gift to the next generation. If you can have all the deeds together. And then I find mistakes all the time. People don't understand that the way you take title to land directly impacts how it passes at death. And I had a lady with 4 kids, and she'd been buying farms with son. And they were going in halvesies, and the plan was when mom died, he was going to buy out her half of the land. But they titled half of them joint with rights of survivorship and half joint as tenants in common. And so really those 3 other kids were only going to get value on the tenants in common ground, and the others were just going to be to the son. And it's just how you sign the purchase agreement. And then did anybody look at this going through closing? No.
But Polly, I would say that a lot of clients, you know, not just farm estate planning clients, you know, like family law clients, real estate clients, you know, don't even really understand the difference between joint tenants with rights and survivorship or tenants by the entirety in comparison to tenants in common. I feel like a lot of people don't even understand that makes a huge difference as far as like you said, with inheritance and all of that. So what are your thoughts there on just sort of educating the agriculture community on how you own your property?
Education is important. And so it's our job to teach people that deeds matter, ownership matters. Your last will and testament does not govern joint property with rights of survivorship. I say you just leave the will in the drawer, and by operation of law, the surviving joint owner. Oh, sorry about that one.
Somebody needs an estate plan, Polly. They're calling you.
Ringer off. So rights of survivorship is the perfect fit for a whole lot of married couples. Even for 2 people who that's actually what they want. When I die, you will own all this. The last man standing gets it. Great. If that's what you want, we leave it as is. But if the plan is we've each put in some money and we're each going to pass our percentage ownership in this land on separately, well, then it better not have rights of survivorship attached. So It's just one of many little details that are important. And pretty much during my first meeting, I just hammer home on that fact. The details are crucial, and we got to make sure it's like a giant jigsaw puzzle and all the pieces fit together and complement each other so that their goals are achieved. I can't tell you how it should be until I know how you want it to be.
That's a good point. So going back on sort of your overall process, we sort of talked a little bit about the information gathering stage, and then I'm guessing that you're kind of shifting to like the discussion and the planning stage. I'm wondering how business entities, business planning play a role in that discussion.
So once I've learned about the family, and then I start nipping at the goals and what do they want, and if the goals is for the whole farm to stay together with multiple owners, then they need an entity around it. So if mom and dad die and they want their kids to co-own the land, I'm going to recommend an LLC in Indiana. It is a terrible idea to just let all the kids' names be on the deed and assume they're going to figure it out, especially if there's a strong feeling about who's going to farm that ground. If there's a related successor or a non-related successor that ought to have the right to farm that for a period of years until retirement, maybe not forever, but if they want some strings attached to what's going to happen to that ground next when they're gone, they need a structure around it. And that's either going to be an entity like an LLC or a continuing trust that holds title to the land and has all those rules written in it. Pretty much having several kids' names on the deed and assuming they're going to work it out, it's going to be a terrible disaster. The other thing about...
Oh, go ahead, I'm sorry.
About an LLC or having farmland owned by an entity is that you can control future ownership. You can have buy-sell provisions, transfer restrictions, that if one kid gets divorced and their chunk of the land LLC is at risk for division, or someone dies and their spouse is going to inherit it, and we really don't want spouses owning our farmland, you can have restrictions in place that help to govern those occurrences, so we make sure the ownership stays among the blood, in the blood.
Yeah, those are great points. I'm sure, are there some instances where you might recommend life insurance to help, fund those buy sells?
Yeah, I talk about life insurance a lot, and I always have to make it clear, I don't sell it. I don't sell life insurance, but it's just one tool in the toolbox, especially when we are dealing with illiquid farm assets, whether it's machinery and equipment or land. If we need cash to buy out interests, then it can be a great idea for there to be a big old cash infusion at death. I describe it like prepaying for the farm on a discounted basis. So yeah, maybe you're paying life insurance on your uncle's life and he's still alive and you're coming out of pocket paying that insurance premium, but when uncle dies, you get a bunch of money and you buy out his widow and then you own that piece of the farm. So you were going to have to pay for it anyway. You just started paying a little bit at a time during lifetime. So back to the team approach, having an insurance professional at the table who can help identify the right kind of policy that does what we need it to do and maybe doesn't do too much else, right? We're not talking about an investment in life insurance here. We just really want to make sure we have a death benefit come due, come payable when we need it. That's an important piece of this.
On your comment regarding the team approach, you mentioned the insurance agent. Would there be anybody else during that that stage that you might bring into the conversation on a case-by-case basis?
Yeah, so always the accountant, because most of my succession planning clients don't want to talk to me about what happens when they die. They want to talk to me about, hey, how do I bring my son into operations? How do I bring my neighbor into operations? Or how do I retire? I'm like, well, but I want to write down what happens when you die. Well, they don't want to talk about that yet. They want to talk about retirement. Well, that is very much an income tax event that needs the accountant at the table. But same, even if we're just doing succession planning and we're introducing entity ownership, so a new LLC or maybe an S Corp is going to help for operations, the accountant needs to be right there on the front end because they're the ones that's going to be doing the tax returns and helping making sure that the books are set up properly so that it works like it's supposed to. So always the accountant on the team approach.
What do you say to those farmers that, want to try to get a child involved in the farming operation that really hasn't had a big role? It's probably a bit overwhelming on really how to transfer that knowledge to the succeeding generation. What are your thoughts, Polly?
So you can transfer knowledge without bringing them into ownership. And really that ought to happen first. So this again kind of gets to the softer side of this succession planning. I can't tell you from a legal perspective when's the right time to bring your son into ownership, which involves risk and reward, right? You either have a good year or a bad year. Do they have the capital to contribute or to get the operating loans necessary to put out the crop? If not, then they're probably just going to be an employee for a while. But let's set up the plan so that if you died, they could come into operations easily, right? Well, I forget what I was going to say there. But the first part was good.
So Polly, thank you so much for coming on today's podcast. And I'd love to tell our listeners where can they find you? What's your contact information?
So my website is dobbslegal.com. It's DOBBSLEGAL.com. If you scroll all the way to the bottom, there's a video about my family farm that Farm Journal put together for their legacy project. So that's kind of interesting because I practice what I preach. I mean, my own family went through this succession planning process when we moved home because I've got 4 other siblings who all live off farm. So go to my website, it'll have a way to contact me, phone numbers, and a nice little introduction to my family farm. You've said it several times, education is just important. This is tricky. I wish it was easier. I wish it was more cut and dry, but just learning and reading and educating yourself and then talking to somebody who can help you get a plan in place. That's the best way to make sure your farm has a successful transition.
Polly, briefly, could you tell us a little bit more about the Legacy Project?
So Farm Journal years ago identified this as such an important topic that was the agricultural community was being underserved. They did not understand the nuances of estate planning and succession planning, and the graying of the American farmer puts this on the top 10 issues facing family farms across the nation. So Farm Journal's Legacy Project has an advisory committee of, I think there's 10 of us who work together to put programming for seminars in the winter and to write articles that are published in Farm Journal. We all take turns submitting our articles, but just trying to educate and in practical terms, right? Just here are some practical examples. Not a whole bunch of legalese that's hard to understand, but hey, if you died tomorrow, here's what would happen to your farm. And if you don't like that, then put a plan together that does what you do want to happen. So the Legacy Project is all about educating farmers and helping connect them with advisors who can help put succession plans together.
And you were very right. You've written a lot. You're a prolific writer, and so you've got some great pieces. I know that we met in January, and there was an article that you had handed me that day. So you're very good, and I encourage our listeners to go to your website and please reach out to Polly. So any other last thoughts, Polly, on farm estate planning before we close?
I'm thankful that you're shining a light on it because it is important, and the more we can talk about it, the more families we can help. So thank you.
All right. Thanks again.